Hi friends, welcome to this discussion on the previous year polity questions. We have been doing this series and today we are going to look at the questions from the 2017 Civil Service Prelims exam. So as always in the other videos, what we are going to do is we are going to put the question, I will discuss about it and then we will arrive at the answer. And if there is some technique of elimination which can be used for that, we will use that as well. And the concept underlying the question and the key points relating to the question, that also we will briefly discuss before arriving at the answer, right? So, are you ready? Shall we start? Yes? So, 2017 was a polity heavy question paper, loaded question paper, good questions but easy as well. Slightly tricky in some places, but overall if your understanding and conceptual understanding is good, you wouldn't have made any mistake, right? No one would have made any mistake. And for people who are going to appear, I hope this discussion will help you in conceptually understanding some of these points. So first question, which of the following is not a feature of Indian federalism? So UPSC does ask which is the following is incorrect, which is not a feature, which of the following do not form part of it. So you should be careful about it. Of course, when you read the options and when you realize that 2, 3 seems right, then itself you will come back and look at the question again, right? And you will pick up this word not, but the question is, of these 4 features, 3 of the features are features of Indian Constitution. Now many people confuse this word federalism and think this question is about which of the following is not a federal feature, which of the following is therefore a unitary feature. No, it is not talking about federal or unitary features. India is a federation, right, with of course unitary features, fine. The question is which of the following is not a feature at all of Indian federalism, which means which of the following is not a feature of the Indian Constitution. So because you should not get confused, there is an independent judiciary in India. It is a feature of the Indian Constitution. Unless there is a judiciary in India, unless there is an independent judiciary, it cannot function as a federation. So Indian Constitution also provides for a judiciary, an independent judiciary. Of course, Indian judiciary is not federal in character, it is unitary, it's integrated. So that's a unitary feature of the Indian Constitution. It's an integrated judiciary. But again guys, this is where some of you who may get confused, look at all the options quickly and then if you have any further confusion, look at the question again and then decide. The question is which is not a feature of the Indian federalism, which means first let us look at all the 4 options and decide, is there anything which is not a feature at all of the Indian Constitution? Because that is what the question is. It is not talking, it's not asking which of the following is a federal feature or a unitary feature. It's saying which of the following is not a feature at all. Independent judiciary, we do have. Powers have been clearly divided between the union and the states. Yes, Schedule 7, division of powers in the union list and state list. Federating units have been given unequal representation in the Rajya Sabha. This is a non-federal feature you would have studied. In fact, in many of the books you would have studied one of the unitary feature or non-federal feature of the Indian Constitution is that unlike in the US, where in the Senate they have equal representation for all the states, 50 into 200 seats, in India we have unequal representation. It is based on population. Uttar Pradesh has 31 seats, Tamil Nadu has 18 seats, whereas Sikkim has just 1 seat. How is it determined? Based on the population. So it is a non-federal feature. But the question is not about which of the following is a unitary feature or not a federal feature. The question is which is not a feature at all of the Indian federalism or Indian Constitution. Look at the final thing. It is a result of an agreement between the federating units or amongst the federating units. This is not a feature of Indian federalism. This is what happened in USA, where on July 4th, 1776, 13 different states which were all colonies separately under the British rule, they came together. They said we are no longer colonies of British. We will come together and form a country, a federal country called the United States of America. And that is how USA was formed. Whereas India, it was not that Bombay province, Madras province, Bengal province were all separately under the rule of the British. And only on August 15th, 1947, these provinces came together and formed the country called India. India was formed. Of course, the princely states agreed to join the Indian Union with the respective states. But the princely states were smaller, the area wise and population wise, they were much smaller in number. The British India, which was the provinces, was all there already. And in fact, after that, we have continued to divide the states on linguistic basis, based on demands like Jharkhand, Chhattisgarh and all. Now, for strategic reasons, we have even divided Jammu and Kashmir last year. So, the last point is not a feature. So, again I am telling you, don't get confused whether it is a federal feature or a unitary feature is not the question. The question is which is not a feature at all of the Indian Constitution, and the correct answer for this is D. Is that clear, guys? Right? So, now let us move on to the next question. Out of the following statement, choose the one that brings out the principle underlying the cabinet form of government. Now, whenever you find such questions, it's a big question, isn't it? 4 big statements you have in the examination hall. The first thing that you need to do is quickly read all of them. And then if you have any doubts, you will be able to eliminate some of them, and then if you have any doubts between 2 options, then you can just apply your mind only on that and decide, right? So, don't start thinking about the first statement after you read the first statement. First, always look at all the statements in any question. Look at the options, because you will be able to eliminate few options based on your knowledge. If you are sure something is right, you will be able to immediately eliminate one option. If you are sure something is wrong, you will be able to eliminate some options, isn't it? So, let us look at this. An arrangement for minimizing the criticism against the government whose responsibilities are complex. Don't make your opinion while reading the first time and hard to carry out the satisfaction of all. A mechanism for speeding up the activities of the government whose responsibilities is increasing day by day. A mechanism of parliamentary democracy for ensuring collective responsibility of the government to the people. A device for strengthening the hands of the head of the government whose hold over the people is in state of decline. Now, when you read it itself, the first one, an arrangement for minimizing criticism against the government. In a democracy, governments can always be criticized, so automatically A is out. A device for strengthening the hands of the head of the government whose popularity is diminishing. If the popularity is diminishing, then the head of the government, which is the Prime Minister or the Chief Minister, will be changed. But that is not for what cabinet form of government is formed. So, D also immediately you can remove. Now, B is a mechanism for speeding up the activities of government whose responsibilities is increasing day by day. So, cabinet form of government did not come into being only because the responsibilities are increasing day by day, and because of that they wanted to create more and more portfolios and give more and appoint more and more ministers to the Council of Ministers and cabinet so that it can be distributed. Yes, it does serve the purpose of a cabinet form of government, but which is the one which brings out the principle underlying cabinet government? The principle underlying cabinet form of government or parliamentary democracy is that the Council of Ministers are collectively responsible to the Lok Sabha in India. But Lok Sabha is ultimately the will of the people, because people elect the members of Lok Sabha. So, don't think collective responsibility of the government to the people, collective responsibility is only to the Lok Sabha. This is not a direct statement from the constitution that is being tested. This is the underlying principle that is being tested. What do you mean when in the cabinet form of government, the Council of Ministers or the ministers, it's a form of parliamentary democracy where they are collectively responsible to the people? Yes, that is the underlying principle, and it is representative democracy. That is why people are represented through the MPs whom they elect in the Lok Sabha. Yes, so the correct answer for this is C. Clear? So that is the answer for this question. Now let us move to the next question. Which of the following are envisaged by the right against exploitation in the Constitution of India? Very, very straightforward question. Straight. Article 14 to Article 30 you should know. Article 14 to 18 is right to equality. Article 19 to 22 is right to freedom. Article 23 and 24 is right against exploitation. Article 25 to 28 is right to freedom of religion. Article 29 and 30 is what? Educational rights. What is the first word? I am forgetting. Yeah, cultural and educational rights. So now, what is Article 23, what is Article 24? That is all. Prohibition of traffic in human beings and forced labor, Article 23. Abolition of untouchability, Article 17, out. Protection of interest of minorities, cultural and educational rights, out. Prohibition of employment of children in factories and mines, Article 24. So it is Article 23 and Article 24, which is Statement 1 and Statement 4. So the correct answer for this is C. This is straightforward from the Constitution. Yes? So very, very simple and straightforward question. Which of the following are not necessarily, again, not necessarily the consequences of the proclamation of President's rule in a state? So what does it mean? Whenever there is a presidential proclamation under Article 356, there are certain things which will definitely happen. What is the first thing that will happen? State government will be dismissed, isn't it? Because if you have the Council of Ministers headed by the Chief Minister, then it is not President's rule, it is the government's rule, isn't it? State government's rule, Council of Ministers headed by Chief Minister's rule. The first and foremost, so there is certain things which will compulsorily happen. There are certain things which may or may not happen. So what is the question? Which is not necessarily a consequence of President's rule under Article 356. So first, dissolution of state legislative assembly, removal of the Council of Ministers in the state. Now, if you look at it, removal of the Council of Ministers in the state is, so it is not there in option B. So clearly option B is out, isn't it? Dissolution of the local bodies, right? Which is not necessarily, what will not happen? Dissolution of the state legislative assembly is not necessary. Which of the following are not necessarily the consequences? Oh, sorry. Yeah, so I'm so sorry guys, I got it completely ulta. Which of the following is not necessarily the consequence of proclamation of President's rule? Removal of Council of Minister is definitely a consequence of presidential rule. So the question is, which are not necessarily a consequence? So even after President's rule, this may not happen. So three choices have two as an answer. Sorry, the correct answer is B in this. By you don't even have to, you should be conceptually clear that state legislative assembly may be dissolved or may be kept in suspended animation. Sorry, see, look, not necessary, necessary, quite possible. I have prepared for this class before, I went through the questions, but even then I was caught off guard. In fact, I was eliminating it, whereas because 2 is not there only in that is the right answer. So it's a learning, it's a learning for me as well, to be careful, but more importantly, my learning is not going to cost me much because I'm not going to write the exam, guys. But this is a live learning for you guys, that be careful, concentrate, and what you need to eliminate or not eliminate, understand, read the question one more time so that you are not caught off guard. Which of the following is necessarily which is necessarily a consequence of proclamation of emergency? That is what I was thinking while I read the question. That is what I was thinking, and I said 2 is not here, so this should be eliminated and we will search for answers in the balance 3. Then I realized, the question is which is not necessarily a consequence, which means if there is an option which does not have 2, then that is the right answer, because other 3 have 2 as an option and 2 is necessarily a consequence. The question is which is not necessarily a consequence. Are you able to follow? So these 3 cannot be the option, because necessarily when a President's rule is imposed, the Council of Ministers have to be removed from the state, and there is only one option which does not have that, and so that is the correct answer. But again, check, dissolution of state legislative assembly, not necessarily a consequence, because the assembly may be dissolved, but it may be kept in suspended animation also without being dissolved, so that it can be explored whether a new government can be formed after the present government is removed. Dissolution of the local bodies has got nothing to do with Article 356. It is only for the state government. Local bodies is a separate Panchayati Raj institutions. They will continue. It has got no bearing on whether the state government is continuing or not. So the correct answer for this is B, 1 and 3 only. Yes. In India, judicial review implies which of the following? Again, 4 statements. Quickly read them and then you can decide. The power of judiciary to pronounce upon the constitutionality of laws and executive orders. The power of judiciary to question the wisdom of the laws enacted by the legislature. The power of the judiciary to review all the legislative enactments before they are assented to by the president. The power of the judiciary to review its own judgments given earlier in similar or different cases. Now, power of judiciary to question the wisdom of laws. That is something which the US Supreme Court has under substantive due process of law. We have procedural due process where the wisdom of the procedure can be questioned, but the reasonableness of the procedure can be questioned. That is what the Menaka Gandhi case talks about. But you cannot question the wisdom of the legislature in India, right? In India, we have limited judicial review. When you say limited judicial review, you can look into it whether it is constitutionally valid or not constitutional. But even in that, there has to be reasonableness, right? Just because it is following procedure established by law, something automatically will not pass the test of constitutionality. Because in Menaka Gandhi case, the Supreme Court clearly said that procedure established by law cannot be arbitrary, cannot be unreasonable. It cannot be against the principle of natural justice. So we have due process of law when it comes to the procedure where the courts will test the reasonableness, but they cannot question the wisdom. Before the president assents to a bill, it doesn't become a law at all, so there is no question of review. So actually judicial review means what? Judicial review means reviewing. If there is a law which is passed, it is subject to judicial review. Any order that is passed by the government, it is subject to judicial review. Now, Article 370, abolition, it is being filed, a case has been filed. Constitutional Amendment Act, there is a case which has been filed. I mean, I don't know when the Supreme Court will listen to all these cases. They are very busy listening to the suo motu contempt cases, right? And ordering 1 rupee fine and so on and so forth, whereas there are much larger real issues which is affecting millions of citizens. Anyways, that's for the Supreme Court to decide. I mean, I hope they don't charge me for suo motu contempt. I am of course not such a big person, but still I am saying. So, judicial review is what? Reviewing the decisions of the legislature and the executive. Should be very clear. But now many people, and I know some of the brightest students who study in our officers IAS Academy, they made a mistake in the exam also, and even now when we do this class in the classroom training, when we do the previous year questions, many people jump, review, sir, answer is D. No, the power of the judiciary to review its own judgments, and that review jurisdiction is primarily with the Supreme Court. High courts don't have review powers unless, you know, it's a error apparent on record. The review power is vested with the Supreme Court of India under Article 137 to review its own decisions. Right to privacy was not earlier declared as a fundamental right, but in 2018 they reviewed their own decision and declared it as a fundamental right. In 2010, homosexuality decriminalization, section 377 was allowed as being constitutional, but in 2018 the Supreme Court Constitutional Bench overturned its judgment, reviewed its judgment and made it unconstitutional. So that is the review power of the Supreme Court with respect to its own judgment. It's the review jurisdiction. But what is the question? What does judicial review imply? Judicial review is the power of the courts to review legislation and executive action. Understand? Is that clear? So review is review of its own judgment. That's the review jurisdiction. There are so many examples like that which you can give. NEET was declared as unconstitutional in 2013. But in 2016, a constitutional bench said that no, NEET is compulsory and it should be conducted. So that is reviewing its own judgment. Obviously, the Supreme Court should have its powers. Because with the changing times, if it has to review its own judgment in line with the present circumstances, it should have that power, and that is the power which is conferred on the Supreme Court under Article 137. But the question is not about what is review jurisdiction. of the judiciary, of the Supreme Court. The question is, what do you mean by judicial review? Judicial review is the power of judiciary to pronounce upon, to decide upon the constitutionality of laws and executive orders. So the correct answer for this is, guys, A. Consider the following statements. The Election Commission of India is a 5-member body. Now if you look at this statement, the moment you look at this statement, you can eliminate A, because you know it's a 3-member body, right? Keep looking at it. Union Ministry of Home Affairs decides the election schedule for conduct of both general elections and by-elections. Election Commission only decides. No, I mean, when you are reading, I told you read everything and then go to the option. But when there is something which is blatantly wrong, when you see and you know that it is blatantly wrong, immediately look at the options also. So 2 is also wrong and there is no none of the above. So the answer is D. I don't even have to look at the third statement. The third statement has to be right. Because if 3 only was given and none of the above was given, then you will have to look at 3 also and decide whether third is also wrong or right or wrong. But here, which of the following statement is correct? You know first statement is definitely wrong. You know second statement is definitely wrong. And there is one option 3 only. So even without looking at the third statement, I mean, don't do that in the examination hall. But this is the elimination which you should be very comfortable with as you practice more and more. Election Commission resolves the disputes relating to splits, mergers of recognized political parties. Yes. The answer is 3 only. And why was this question asked, guys? You please understand why these questions are asked in UPSC. Some of them are straightforward, conceptual and all that. But many areas the UPSC also picks up questions based on current affairs. This question came in 2017 when there was 2 bitter fights happening in India. One was father and son fighting for cycle. Samajwadi Party, Mulayam Singh Yadav and his son Akhilesh Yadav, they fought who should have cycle symbol, right? Faction. Then finally Mulayam Singh Yadav, the son Akhilesh Yadav faction was declared as the official Samajwadi Party and he got the cycle symbol. Similarly, for 2 leaves, 2 factions were fighting here. The OPS camp and the Sasikala camp that time, which had EPS also at that point of time, right? And then now EPS and OPS are together. Yeah, so that is how politics works in our country. So for those of you outside of Tamil Nadu also, you must have followed this news. So that was also determined by the Election Commission. So it is because there was an issue relating to that, this question was asked, right? So the correct answer for this is D, 3 only. Yes. Right to vote and to be elected in India, again 2015 Rajbala case. Rajbala and others was a state of Haryana. When there was an amendment to the, I mean, I will not get into that details because that's a separate discussion altogether. There were amendments to the Panchayati Raj Act in Haryana and Rajasthan, which required some certain educational qualification for contesting elections, and that was challenged in the Supreme Court, saying that it is taking away the fundamental, it's taking away, it's unconstitutional. Anybody should be allowed to contest. That is what political democracy is about. It is against the it's an arbitrary restriction and it takes away, it's not a reasonable restriction. It takes away the freedom of speech and expression, which is also reflected by contesting elections and all those stuff. But finally the Supreme Court upheld that law, and in that law it again reiterated what is already there in the Constitution, but it reiterated. See, right to vote is not a fundamental right. Right to contest election is not a fundamental right, because under Article 14 to Article 30 you will not find those rights. Yes? So what right it is? It's a constitutional right, because you have right to vote under Article 326. It says anybody above 18 years of age and who is not disqualified under any law, there should be no discrimination and everybody should get the right to vote. So the Representation of the People Act 1950 gives the qualification for being a voter, gives the disqualification for being a voter, all that is fine. But where does it flow from? It flows from the constitutional right to vote. And similarly, what is the qualification for contesting in an election? You are a citizen, you should be about 25 years of age for Lok Sabha or MLA and 30 years of age for Rajya Sabha or MLC, and such other qualification as may be prescribed by a law. And that qualification for being a voter, is provided in Representation of People Act 1951, which says that you should be an elector to be a contestant. Qualification for being a member. So fundamentally these are constitutional rights. Yeah, so basically these are constitutional rights, and this is again based on 2015 judgment. That is why again in 2017 it was asked. It is a constitutional right. The correct answer is C, constitutional right. Yes. Consider the following statement. In the election to the for the Lok Sabha or State Assembly, the winning candidate must get at least 50% of the votes polled to be declared elected. One is out of the window, isn't it? So option A and option C are gone. Because you know it's first past the post system in India. Whoever gets the maximum votes get elected. It is not that the winner has to get at least 50% of the votes. According to the provisions laid down in the Constitution of India, in Lok Sabha, the Speaker's post goes to the majority party and the deputy speakers to the opposition. Constitution, does it say? Constitution only say the House will elect a speaker, the House will elect a deputy speaker. It's only based on convention after the 10th Lok Sabha that the speaker post has gone to the ruling party and the deputy speaker to the opposition party. It is not as per the provisions of the Constitution of India. It is a practice. Convention means what? It is not written in any law or any rule. It's just a practice which has been followed, which is a convention from the 10th Lok Sabha. So the correct answer is neither 1 nor 2. Yes, the answer for this is 8. Question is D, neither 1 nor 2. For election to the Lok Sabha, a nomination paper can be filed. Again, 4 statements, quickly read all of them and then arrive at your answer. Anyone residing in India, a resident of the constituency from which the election is to be contested, any citizen of India whose name appears in the electoral roll of a constituency, and any citizen of India. So now basically this is qualification for being a member. That is the question. They have asked it in a different way. For filing a Lok Sabha nomination, who can file? Qualification for being a member, citizen of India. So here it is only resident, A and B is out. C and D is both having citizen of India. So the choice is between C and D. But is being citizen of India and age sufficient? You should also satisfy the qualification as prescribed by any law made by Parliament. That is what the Constitution says, and that law is Representation of People Act 1951. And in that Representation of People Act 1951, what does it say? A person to be qualified to be a member, which means if you have to file a nomination paper and contest an election, and if you have to become a member, you should also be an elector. So if your name is there in the electoral roll of any constituency, for Lok Sabha it can be of any constituency. For the state, you will have to be an elector within that state. So Mr. Narendra Modi, when he was Chief Minister of Gujarat, couldn't have gone and contested in Maharashtra and become Chief Minister of Gujarat. He has to be an elector within Gujarat to be able to contest within Gujarat. But to contest the Lok Sabha, he can be an elector in any constituency. That is why he is an elector in Gandhinagar, in Ahmedabad, in Gujarat, but he is contesting from Varanasi. Or for that matter, Mr. Rahul Gandhi contested from Wayanad while he is an elector from Delhi. So you will have to be an elector in any constituency, then you can contest a Lok Sabha election. So the correct answer for this is C, right? The Parliament of India exercises control over the functions of the Council of Ministers through adjournment motion, question hour, supplementary questions. See, always this is what we call as list questions. Invariably in list questions, all of the above, again, it's not something which can be applied blindly, but it is a technique which you can use depending on, of course, your knowledge. But invariably first see whether something is definitely wrong. Otherwise, usually in such list questions, all the options are invariably correct. But again, polity technique is dicey. There are many techniques which we also tell our students to use it in combination with the knowledge. Of course, we teach knowledge here, that is our primary purpose, but this last minute techniques can, help you get the right answer. Anyways, all these three are ways of legislative control over the executive, right? Adjournment, question hour, supplementary questions, no confidence motion, calling attention motion, adjournment motion, all these are ways of executive, legislative control over the executive. So the correct answer is D. Last question, which of the following statements are true of the fundamental duties of an Indian citizen? So now this is a very interesting question, a conceptual question. Fundamental duties, which of the following is true? A legislative process has been provided to enforce these duties. Very straightforward, isn't it? You know that directive principles are not enforceable against the government in a court of law. Similarly, fundamental duties are not enforceable against the citizen in a court of law. This is something basic, whereas fundamental rights are enforceable by the citizens directly in the Supreme Court. This is the basic thing which anybody who is taking the UPSC exam who has studied the constitution will be aware of. So the first statement is wrong, is very straightforward. A legislative process has been provided to enforce these duties. No, fundamental duties are ideals which the citizen should follow. So there is no law, there is no legislative process to enforce them. So the first statement is wrong. So the option A and option C are out. Now look at the second statement. They are correlative to legal duties. See, rights are correlative with duties is a correct statement, because fundamental rights you have which is enforceable, fundamental duties you have which is not enforceable against the citizens, but they are correlative, right? That is the, when the 1976, when the fundamental duties was introduced as an amendment to the constitution, they wanted to say that we have a set of fundamental rights, but correlating to that we also want these ideals to be followed by the citizens. So rights are correlative with duties is a correct statement, which was asked in 2017 or 2018 exam, one of these exams. But here, are they correlative to legal duties? What do you mean by a legal duty, guys? Legal duty is something which you are bound by law to do. So automatically, if you understand that itself, you will know the second statement is also wrong. Because when there is no law to enforce the duties, how can it correlate to any of the legal duties, the fundamental duties, isn't it? So automatically the second statement is also wrong. But just for additional understanding, what is a legal duty? Something which you are legally bound to do. If you are earning income above certain limit, you are legally bound. It's your legal duty to pay income tax. If you don't do that, you are committing a legal offense. If you are driving a two-wheeler or a four-wheeler, it is your legal duty to obtain a license from the transport authority before you drive your vehicle. If you are not doing that, you are committing a legal offense, isn't it? That is a legal duty. Whereas fundamental duty are ideals. They are not enforceable and they do not create any legal duty per se. I mean, if you go and break public property, you are committing an offense because under the sections of IPC or CRPC, it may be an offense and you may be booked. But you will be booked for violating that law, not for violating the fundamental duty of protecting public property. Understand? So it is not correlative to legal duties. So the correct answer again for this is D, neither 1 nor 2. Yes. So guys, I hope you found this discussion useful. I told you some techniques of elimination and how to approach the questions as well. And I have also conceptually explained the underlying reasons why the answer is, why a particular option is an answer. So I hope you found this useful. I'll see you again with more videos in future. All the best. Good luck.